Hello, this is Professor Weissman's PowerPoint presentation designed to teach the remainder of the Criminal Justice Process course remotely. It can be accessed on Blackboard and YouTube at Professor Weissman's CJ Courses channel. I will email the YouTube link when it becomes available. The presentations over the next 5 weeks will concentrate on the privilege against self-incrimination, Miranda warnings, immunity to testify, confessions, identification techniques of suspects, and confrontation of witnesses. There will be 5 units altogether, with each unit corresponding to a different week. Each unit will be posted online generally on Monday or Tuesday mornings. The dates of the units are Unit 1, March 23 through March 29th, Unit 2, March 30th through April 5th, Unit 3, April 6th through April 12th, Unit 4, April 13th through April 19th, Unit 5, April 20 through April 26th, and finals May 1 through May 5. In Unit 1, we will be looking at the privilege against self-incrimination, including the purpose of the privilege, who can assert the privilege, when the privilege can be asserted, the scope of the privilege, when a violation of the privilege occurs, the compulsion requirement, and burdening the assertion of the privilege. The Fifth Amendment of the United States Constitution reads, in relevant part, "No person shall be compelled in any criminal case to be a witness against himself." This, of course, is the well-known privilege against self-incrimination, which stems, like so many principles of the American criminal justice system, from England. There are 3 basic reasons for the privilege against self-incrimination. The first is reliability. It is thought that compelled testimony that is self-incriminating is often the product of coercion and not of free will, so the statements may not be reliable. The second is the avoidance of coercion. The privilege helps prevent coercion as a tool of law enforcement. And third, our system is adversarial in that prosecutors have the burden to prove a defendant guilty. So, it is not defendant's job to prove innocence as it may be under an inquisitorial system. We now look at who can assert the privilege. First, only natural persons can use the privilege, not corporations or other entities. Second, the privilege is personal. It can only be asserted by a person when testimony will incriminate himself or herself, not another person. For example, if person X is testifying on the stand about how bad person Y is, person Y cannot assert the privilege to prevent person X from testifying on the witness stand. Of course, a person's attorney can assert the privilege on behalf of his or her client. When can the privilege be asserted by a person? The privilege against self-incrimination can be asserted by a defendant or even a suspect at any proceeding, be it criminal, civil, administrative, at which the government might compel incriminating testimony from the person for use at a later prosecution. Also, it can be asserted at any stage of the criminal proceeding, pretrial, grand jury, custodial interrogation. For example, in the case Ohio versus Reiner, a babysitter who claimed to have had nothing to do with the baby's death could properly assert privilege at the baby's father's trial for murder, where the father's experts had testified that the baby's fatal injuries could have been caused by that babysitter. It should be noted that the individual must claim privilege at the time of questioning. The individual cannot answer the question voluntarily, then assert the privilege later on. That operates as a waiver to the privilege. What is the scope of the privilege? First, the privilege applies only to self-incriminating testimony. The privilege, however, is very broadly construed so that even a link in the chain of evidence needed to prosecute a person can fall under the privilege. For example, in the case Hoffman versus the United States, the defendant claimed that answers he may give might tend to incriminate him of a federal offense. He then refused to answer certain questions asked him by a special federal grand jury, which was making a comprehensive investigation of violations of numerous federal criminal statutes and conspiracies to violate them. The questions he refused to answer pertained to the nature of his occupation and his contacts and connections with and knowledge of the whereabouts of a fugitive witness sought by the same grand jury and for whom a bench warrant had been requested. The judge who had impaneled the grand jury and was familiar with these circumstances found no real and substantial danger of incrimination to Hoffman and ordered him to answer. Hoffman refused to answer and he disobeyed the order. As a result, he was convicted of criminal contempt. The case was appealed all the way up to the U.S. Supreme Court, which reversed Hoffman's conviction. The court stated that the privilege against self-incrimination guaranteed by the Fifth Amendment extends not only to answers that would in themselves support a conviction under a federal criminal statute, or a state statute for that matter, but also to those which would furnish a link in the chain of evidence needed to prosecute a person, in this case Hoffman, for a federal crime. Second, it should be noted that foreign prosecutions are not considered criminal prosecutions under the U.S. Constitution, so no Fifth Amendment right attaches. Third, the seizure of physical incriminating evidence is not a matter for the Fifth Amendment, which applies only to testimony. Accordingly, the government can compel a suspect to submit to blood tests, to give a handwriting and voice sample, also known as an exemplar, produce fingerprints, and participate in a lineup and mugshots. When does a violation of the privilege occur? A violation occurs only when compelled statements are actually used against a suspect in a criminal prosecution. For example, in the case Chavez versus Martinez, while Martinez was being treated for gunshot wounds received during an altercation with a police officer, he was interrogated by Chavez, who was a patrol supervisor. Martinez admitted that he used heroin and had taken an officer's gun during the incident. At no point was Martinez given his Miranda warnings. Although he was never charged with a crime, and his answers were never used against him in any criminal proceeding, Martinez filed a civil lawsuit, maintaining that Chavez's actions violated his Fifth Amendment right not to be compelled in any criminal case to be a witness against himself. The case eventually went up to the U.S. Supreme Court, which held that a criminal case, at the very least, requires the initiation of legal proceedings, and police questioning in and of itself does not constitute such a case. Statements compelled by police interrogation, of course, may not be used against a defendant in a criminal case, but it is not until such use that the self-incrimination clause is violated. Martinez was never made to be a witness against himself because his statements were never admitted as testimony against him in any criminal proceeding. Let's look at some examples in cases that illustrate the compulsion standard. The Supreme Court has held that certain specific situations lack sufficient compulsion to trigger the Fifth Amendment privilege against self-incrimination. For example, the Fifth Amendment does not protect an individual who fails to file a tax return, even if the individual's income is illegal, for example, illegal gambling. A taxpayer may leave blanks, the Supreme Court noted, on the income tax return if the required information would tend to incriminate, but may not fail to file a return. On the other hand, the Fifth Amendment prohibits statutory registration requirements when mere registration itself is proof of a crime. For example, parts of a federal law which required communists to register with the government were struck down by the Supreme Court as violating the Fifth Amendment. And lastly, a confession or testimony is not compelled simply because it is prompted by a mental illness that prevents it from being the product of the person's free will. Some official compulsion or coercion must be present for a statement to be inadmissible under the Fifth Amendment. For example, in Colorado versus Connolly, a schizophrenic defendant confessed to a murder after the voice of God told him to lead police to the scene of the killing. A confession should not be suppressed because no element of police overreaching was present in this case. The government may not chill the exercise of the Fifth Amendment privilege by penalizing those who try to use it. So, for example, the government may not fire police officers for invoking the privilege during an investigation, nor may the government take away state contracts or prohibit a person from holding a political office for exercising the privilege. Moreover, at trial, a prosecutor may not comment on or question defendant regarding her silence after receiving Miranda warnings. These warnings carry an implicit guarantee that silence will carry no penalty. A prosecutor may not comment on the defendant's failure to testify at trial. However, the prosecutor may comment on the defendant's failure to take the witness stand if the comment is in response to defense counsel's assertion that the defendant was not allowed to explain his side of the story.